Well, good afternoon and welcome to another King's Chambers cost seminar led by myself, Andrew Hogan, and Paul Hughes. Today we're going to be talking about fixed recoverable costs, of which, of course, there's been a lot in the media recently. And we're going to be covering a lot of ground. We've already had quite a few questions sent in by people in advance. We'll try and soak those up as we go along. Of course, we do invite questions as we go along, and you should find the Q&A or chat box, and I'm happy if you use either of those questions, which, as I say, we'll pick up as we go along. There are going to be no slides used this afternoon, but in the aftermath of the seminar, slides will be sent out to all of you who have signed up and attended, and that way you'll have the references and the rule numbers and such like. So that's how we're going to deal with this. Let's deal first of all, though, with the philosophy of fixed recoverable costs, because it's probably the topic which has produced the strongest reaction that I've seen for about a decade and the actual implementation of the Jackson reforms. It's possible to look at it philosophically in a number of ways. On the one hand, you might say that this is a good thing, that it will increase access to justice, because it will enable people to take a view as to what the costs of a piece of litigation are prospectively, and therefore to adjust their position accordingly. And if one also bears in mind that virtually all costs are ultimately paid either by insurance policyholders or by the taxpayer, then they're paid effectively by all of us. And to that extent, if they're kept within predictable, discernible bounds, that's a good thing. The other way of looking at it would be to say that this is a reform which has been put forward quite definitively to favour the interests of paying parties, that it represents a fairly cynical exercise in a USA-style tort reform way, whereby the appearance of people's rights remain, but the substance of them and their ability to access them is hollowed out. Well, we don't have to decide which or any philosophical approach is the better view. There's plenty to talk about in terms of what's actually going to happen in the next month or so. So what we're going to look at today is the story so far, give you an overview of the reforms, pull out some particular crunch points which we think will give rise to satellite litigation over the coming year, look at some of the quantum of recoverable fees, and also think about how these costs would be applied in three particular scenarios. So, for example, a boundary dispute, or a professional negligence dispute, or a personal injury claim, which settles shortly before trial. In terms of how we've got here, in a sense, this is an example of the wheel of history turning again and again. Any Victorian practitioner would have been fully conversant with scales of fixed costs, which applied back in those times. And even into the early modern era, people who are in practice pre-1999 in the county court will have fond memories of Scale 1 and Scale 2 costs. And to that extent, what happened in 1999 when the Wolf reforms were enacted was essentially a retrograde step, because it swept away the old scales of costs, but nothing was brought in to replace them other than the very minor provisions in relation to fast-track trial fees, which principally affected members of the bar. So in a sense, although fixed costs had been part of Wolf's vision, it remained unfinished business. And thus it was only with the Jackson report that fixed costs really began to pick up speed. There had, along the way, been reforms to low-value personal injury claims, but what Jackson was looking at was something which was far more significant and more profound. So after 2013, the next milestone was his Fixed Recoverable Costs Supplemental Report of 2017, and then a further paper published by the Ministry of Justice on extending fixed recoverable costs in 2019, a consultation paper, and then ultimately the government's response, perhaps slightly delayed by the pandemic, with that being published in 2021. And so here we are, after a number of delays, on the cusp of the implementation of the reforms. So there are a number of ongoing issues in relation to them, and I'm going to pass the baton over to Paul at this point.
Thanks, Andrew. The wheels of justice do continue to turn, and the reinvention of the wheel, if the wheel is fixed costs, is going to take place once again, because it's clear that the work that is done is not complete. In response to concerns from stakeholders after the publication of the draft rules, the MOJ have undertaken a consultation with regards to issues relating to the new regime, and they produced recently a revised publication. There are about half a dozen areas in which the MOJ take the view that the job is not yet finished. Those concerns are also the subject of an April judicial review, which is stayed until 3 weeks after the response to this consultation. That consultation ended on the 8th of September 2023. So one awaits the response, but the MOJ's view is that there are, as I say, around half a dozen areas in which fixed costs can be either expanded yet further, fixed recoverable costs can be expanded yet further, or aren't adequately expanded to date within the current rules. The first one is the assessment of fixed costs themselves. Now, when a case goes to trial, it's anticipated that the trial judge will deal with the assessment of the fixed costs by way of a summary assessment. But if a case settles before trial, the MOJ anticipates, and probably rightly so, there'll be disputes, ongoing disputes about points of detail, they say, regarding, for example, the level of damages and when a claim has settled, so which is the appropriate level of fixed costs. In order to remedy that, the MOJ anticipate that there could be a shortened Part 47 procedure, so not as lengthy as the current detailed assessment procedure, but a shortened procedure, which still with perhaps a short bill, some points of dispute, some points of reply, and a short hearing, but a cap of the proposal within the Jackson report was, say, £500 in order to cover that shortened Part 47 procedure. Obviously, they want increased costs to be incurred. That's the first area in which they anticipate that fixed costs can stop ongoing hourly rate basis costs arguments. The second is, relatedly, fixed costs for Part 8 costs-only claims. So cases in which costs, in which Part 7 proceedings have not been issued, it's cost at part only. The MOJ saw that as a gap that needs addressing in order to stop exploitation of extensive Part 8 costs proceedings, the costs of Part 8 cost proceedings. Now, the level of cost that the MOJ anticipates that would be appropriate for the issuing of a Part 8 claim form, consideration of the response, and some short particulars and consideration of the response would be around about £300 for claimant, defendant, £150, presumably plus the appropriate court fee. The third aspect is recoverability of inquest costs and restoration proceedings. Inquest costs, although the subject of a lot of debate and a lot of litigation over the past 10 to 15 years in multi-track cases, are recoverable in principle if they're reasonable and proportionate, at least in certain categories of inquest cost. But there's no provision in the new fast track and intermediate track rules for recovery of those. They're within the general fee provisions. So the MOJ recommend that there should be separate recovery for inquest costs if they're reasonable and proportionate. Likewise with restoration costs, cost of restoring a company to the register. These are included within the fast track costs at 45.56, but they are not elsewhere included. The MOJ recommend that they should be dealt with separately. The fourth area is the recoverability of advocacy fees for settled and vacated cases, the bane of many counsels' life, I'm sure, with cases being settled or vacated late, either a couple of working days before the hearing or on the hearing itself. Well, this is anticipated to be addressed directly by the MOJ with allowance of 100% for a case which is settled or vacated on the day of the trial, and 75% if vacated or settled a couple of up to 2 working days before. As again, relatedly, there's obviously there has been considerable complaint, understandably so, given the rate at which interest has increased in relation to the uprating of council's fees. The fees having been remained effectively stagnant in certain circumstances between 2013 and obviously need to be uprated, particularly now that the rate of inflation increasing in the past 3 years has been exponential. The MOJ take the view that there should be, for fast track, bands 1 to 3, of which more shortly, an increase in the advocacy fees at 4%, but they resisted the suggestion that it should be 20%. As far as clinical negligence cases are concerned, that's the next final point that I'd like to highlight as regards ongoing work. The view is, of course, that the clinical negligence cases in excess of £25,000 are generally unsuitable for the intermediate track unless breach and causation has been admitted. Now, we'll come on to see when we deal with normal track allocation, which still remains a concept and still remains, I suppose, a rule. That would be the normal track for a clinical negligence case, but lower value clinical negligence cases are the subject of a separate consultation, which will probably be the subject of a separate talk by myself, Andrew, or others in due course. So we don't have time to deal with that now, but so we'll park that for the moment. But that is something that should be on your radar. Andrew, I think, will now talk about where the rules are to be found and some overarching themes so that we can learn about the new approach to these cases.
Thank you, Paul. In terms of where the rules are to be found, there is, of course, no substitute for getting yourself a lever arch file, printing out the relevant new rules, and then just going through them with a set of stickies and a marker pen to go through it yourself. But what you need to be looking at is the revised Part 26, which deals with allocation, Part 28, which now deals with the fast track and the intermediate track, an entirely new and recast Part 45, which is the Bible on fixed costs. And all of this can be found to flow from the Civil Procedure Amendment Rules of number 2 of 2023, also to a lesser extent the Civil Procedure Amendment Rules number 3 of 2023, and a practice direction making instrument which contains the detail, the actual tables and the figures of the costs applicable to the various categories of case. In terms of the way that the new scheme of fixed recoverable costs is to be applied, as I think Paul has foreshadowed, it's a question of evolution of the current structure rather than sweeping it away and bringing in something brand and new. What we see is that since 1999, we've had this structure of small claims track, fast track, and multi-track. What they've done is stretch out those concepts so that you retain the small claims track and the fast track, but you put between the fast track and the multi-track a new track, the intermediate track, so-called because it's between fast and multi, so that you have 4 tracks going forward. And the scheme of fixed recoverable costs that we're principally concerned with is going to relate to the fast track and to the intermediate track. And it therefore follows that if you have a case which can be leveraged into the multi-track, then in a sense nothing's changed. It's still going to be standard basis, for the most part, hourly rate assessed costs when you ultimately come to draw your bill. But it follows that when the court is allocating a track at the beginning of a case, is going to be the key point where it determines which track it goes to, and therefore whether it falls within the scope of fixed recoverable costs or not. The judge on allocation has to make 2 decisions. He has to allocate it to a particular track, fast or intermediate in the cases we're concerned with, and then the court assigns the case within that track to a band. which will be band 1, 2, 3 or 4 on the fast track, or again band 1, 2, 3 or 4 on the intermediate track. And so fast track cases will still remain cases worth up to £25,000, which can be dealt with in a day. Intermediate track cases are going to be cases which run from £25,000 and £1 up to £100,000, but also where there will be no more than 3 days of trial and no more than 2 experts per side giving oral evidence. And of course, within that broad category of intermediate track, there are the 4 bands which are a case will be allocated to, which will reflect its complexity. And the general principle is, or should be, that the more complex a case, the higher band it goes into, the more you recover by way of costs. But as we'll see in a little while, there are some interesting inconsistencies in that approach. Back to you, Paul, for allocation.
So, thanks. Yeah, so allocation is set out at CPR 26.9, and the scope of each track and the concept of what is the normal track for each case is retained, although obviously the inclusion of the intermediate track is a new feature of that rule. The intermediate track, as Andrew highlighted, is the normal track for a case, including monetary claim, for not more than £100,000, no longer than 3 days, and oral evidence from 2 experts each, with 26.9 says no additional factors that would justify it being allocated to a track other than the intermediate track, such as the multi-track. It also refers, by way of completion, to there being a requirement that it's a claim for no more than a claimant against 2 defendants or 2 claimants against a single defendant. Now, there are certain exclusions to the intermediate track at 26.910. And so there's a mandatory allocation of a claim to the multi-track where it's a mesothelioma claim or an asbestos lung disease claim, or there is or it's a claim that involves clinical negligence, unless the carve-out applies and it's a claim to which breach of duty and causation have both been admitted. Also excluded and therefore mandatorily allocated to the multi-track are claims for damages in relation to harm, abuse or neglect of or by children or vulnerable adults, a case that the court could order be tried by jury, or a claim against the police, which includes a claim for intentional or reckless, an intentional or reckless tort, or a relief in relation to the Human Rights Act. So there are certain exceptions to the provision of the facility of the court to allocate to the intermediate track. The matters relevant to allocation to the track, this is before we deal with assignment, are those ones which are familiar to all practitioners. They are ones that have been argued up and down the country on allocation within the existing tracks, and are set out at CPR 26.12 and 26.13. Financial value, nature of the claim, complexity, etc. So far as the allocate, but of course, we're not just dealing with allocation in the evolved regime, we're also dealing with assignment. And that's dealt with assignment of a claim to a complexity band. And that is a new concept for us to grapple with. And that's set out at CPR 26.14. And there's a requirement for the parties to set out within their allocation questionnaires what band of complexity they view the case should be allocated to, or rather assigned to. Now, the parties can agree the appropriate complexity band, or they can argue it before the court. If they agree it's not determinative. The court can take a view that is different to that which the parties put before it. I'll let Andrew talk about the assignment now, within the fast track and then the assignment within the intermediate track, one of the points that I'm sure will be mentioned is that there is a degree of specificity within the complexity band assignment in the fast track that I view as being absent and rather more woolly within the intermediate track. And it might be that we have a little chat about whether that's going to give rise to litigation, because of course the amount that you get by way of recoverable costs is different in each complexity band. But if we deal with that fast track and then multi-track assignment of complexity.
Yeah, and I think, Paul, based upon what you've just said, we can see the argument starting to creep in. If we take, for example, the issue of allocation, due to the level of judicial discretion here, you're going to get some wingback decisions made at various points. So, for example, I've seen cases where small claims have stretched up to £57,000 in the context of credit hire, because the judges take the view that a credit hire case is a credit hire case, and we deal with these all the time on the small claims track. We can also see in this situation that you may have, for example, a personal injury claim where the claim is pitched at £125,000. The claimant's solicitor takes the view, well, this is a multi-track case. But when the defence comes in, it admits 30,000 quid's worth of damages claimed, bringing it down to 95,000, in which case it might be thought to be an intermediate track case. At which point, it may be that the claimant's solicitor, sitting comfortably on an orthopaedics report and a psychiatrist's report, takes the view that they would benefit from the report of a radiologist, at which case it may bob back up again into the multi-track. So all of these arguments are going to start to come out as people feel for the sense as to where a case will be allocated. But coming on to the question of assignment, it's quite obvious that two different people drafted the criteria for assignment on the fast track and assignment on the intermediate track. I can think of no other explanation for the difference in approach. So for Band 1 on the fast track, it's described as an RTA, non-personal injury claim, for example, a bent metal case, or a defended debt claim. Band 2 will be an RTA with personal injury or one of these holiday sickness claims. Band 3 goes up to RTAs which fall outside the current portal, or EL or PL claims, possession or other money claims outside the PI context. And then Band 4 is cases where there's a degree of complexity, complex possession proceedings, property and building disputes, small professional negligence cases, or other complex claims. In relation to the intermediate track, a different approach is taken, not giving the flavours of cases which are fall within a particular band, but giving it a far more discursive element. So if you have a case which has only one issue in it and can be dealt with in one day, as opposed to the notional 3 days, that's a Band 1 case. Band 2 are less complex claims with issues of liability and quantum. Well, what does that mean? Less complex than what? What's the standard here? How thick is the wall between Band 2 and Band 3? Because Band 3 is only described as any more complex claim unsuitable to put into Band 2. Well, again, what are the criteria? What does complex mean? One person's complex is another person's simple. There's nothing to grapple with here. And to then put the cherry on top, Band 4 is simply defined as any claim unsuitable for Bands 1, 2, and 3. So you can have arguments on allocation, and then you can have arguments on assignment. And these arguments are going to matter, because as we see towards the end of the talk, there's a lot of money riding upon which track or which band you end up on. Paul, if I pass back to you.
Yeah. Now, the key provision, as Andrew highlighted earlier on, is CPR Part 45, which has been effectively redrafted, and its accompanying practice direction. The extension of CPR 45 is probably your starting point for your reading in relation to the new Fixed Recoverable Costs rules. The general provisions are set out in Section 1 of that rule, with the particular provisions in relation to the fast track and the intermediate track, which is essentially what this talks about, set out at section 6 and section 7. In the practice direction, as Andrew mentioned, there is a table of figures. Now, to date, it's been relatively easy to remember each of the figures in the relevant table, and one can probably without reference to the tables themselves, come up with settlement figures for costs at the conclusion of any particular claim in any particular case. I'm not sure that's going to be the case unless you have an eidetic memory from here on in, because there are many more figures for fixed recoverable costs and many different percentages of damages. Those tables are well worth a look, and through the perhaps through the eyes of settlement, you'll see that there are certain disparities between cases which settle at band 2 stage 7 and band 3 stage 4, and you'll see that there are certain, I'm not sure where they are at the moment, but there are certain areas in which the costs are generous, and there are certain circumstances in which the costs are not. One of the points that what's been amended, and one of the points that can be looked at is, the provisions that should be looked at is CPR 4515, which it shouldn't be forgotten that it refers to the amendments to CPR 36. Now, before we go on through the remainder of the rules and the scope of Part 45, it might be worth just having a quick word with this, and I'm sure, Andrew, you might have something to say about it. But for CPR 4515, that provides that in the case to which Section 6, 7, or 8 applies, so they're the new sections, where a Part 36 offer is accepted, 3623 applies instead of the relevant section, and where upon judgment being entered, the claimant fails to obtain a judgment more advantageous than a defendant's Part 36 offer, 3624 applies instead of the relevant section. But the redrafting at Part 36 is something that you will want to consider. Although the provisions with regards to the additional amount remain, there is a substantial change to the provisions relating to indemnity costs. So where a claimant is set out at CPR 3624, which amends CPR 3617, but where a claimant obtains a judgment for an amount that is greater than the Part 36 offer, the claimant is entitled to the additional fixed costs incurred during any period applicable from the expiry of the relevant period, but also 35% of the difference between the fixed costs when the relevant period expired and the date of judgment. So instead of the benefit being indemnity costs plus 10% from the date on which the relevant period expired, you're entitled to the fixed costs between the date of the relevant period and the date of judgment, and 35% of the difference between the two stages of fixed costs. Now, that is probably, although worked examples in certain cases might prove, I suppose it depends on how much work would have been done on an hourly rate basis, but that is probably a far less advantageous provision when you beat a Part 36 offer to a claimant than a previous order for indemnity costs from the date of the expiry of the relevant period would have been. As for defendant's costs, well, the rules have changed, but in a way that is perhaps not so disadvantageous. Although the claim the defendant does not get, it's an order for costs from from the expiry of the relevant period to the date of judgment, it gets the fixed costs that are applicable for the date at the date of judgment, less the claimant's entitlement for fixed costs. So effectively, the defendant gets the difference between the two costs. Again, there is no corresponding enhancement, nor as there wasn't in the run-up and the past and in the previous rules, for a defendant beating their own Part 36 offer. They simply get the difference. But the real change, I think, and before we go on to the scope provisions, the real change, I think, is that claimants do not have, although they still get the additional amount, they do not have the benefit that whacking big indemnity basis hourly rate costs order.
I think that's absolutely right, Paul, because one of the effects of the rules, and this seems to have been done really on the basis of neatness rather than anything else, is to take out the indemnity cost provisions and put in this provision where you get an uplift on the difference between stages in the table. But the effect of that is largely to neuter Part 36 provisions. And logically, the consequence of that is it pushes more cases towards trials because defendants don't have to fear Part 36 consequences in the way that they did. And in those circumstances, you get this counterintuitive effect that whereas you're trying to promote certainty, you might simply end up with a lot more trials and a lot more uncertainty because people aren't afraid of the cost consequences if they get it wrong. Now, the questions are starting to arise. People are asking, well, where do we find the new rules? I think people are also starting to post them in the chat box. If you can't find what you need, just Google it, Fixed Recoverable Costs, Ministry of Justice, October reforms, and I'm sure that will bring up what you need. I think also a question has been raised, are there no costs for fast-track cases in complexity band 1 with damages of up to 10k where settlement is pre-issue? The short answer to that is there aren't any costs because that's effectively a small claim. I think it's just a gap in the table which reflects the reality of the situation. In terms of other questions, I think people are starting now to ask points about the detail of the rules. So it may be, Paul, that we start to roll our sleeves up, get under the bonnet and move on to Part 45 and see where we go.
Yeah. Part 45, 45.1 sets out the scope of the rules, and CPR 45.1 provides in a similar way to the current CPR 4529A that the court may award only costs in an amount that are neither more nor less than the fixed cost supply allowed by the applicable section and set out in the relevant table, where a claim is one to which sections 4, 6, 7 and 8 apply. And one of the points that I've been asked by some of my instructing cost lawyers or solicitors is whether or not that changes the position that currently exists as regards whether or not a court can order costs which relate to proceedings which have not been started, and in essence, whether that gives the court jurisdiction to trump freedom of contract, and whether or not you can still contract out the rules. Well, it seems to me that just as with a case in which under 44.5 a court will assess costs pursuant to the terms of a contract, usually do so by default on the indemnity basis, a court's jurisdiction to assess costs, whether it's by awarding fixed costs or otherwise, it is only to be exercised by reference to a rule, practice, direction, or a court order or an agreement. I don't see CPR 35.1 as doing anything other than expressing fixed cost rules to cases to which the provisions apply. I don't see that it will preclude parties from contracting out in a Doyle sense. If the parties accept that the provisions apply or would apply as a matter of law, and that would be a question of law and fact, then the parties could agree that costs should be assessed in a different way. If they are clear that they're contracting out, then they can still do so. Andrew, do you agree with that?
I do, Paul, because you have this situation, I think, in relation to pre-existing arrangements, such as a mortgage, such as a contract, and Rule 44.5 is still there in the lexicon to cater for that situation. What it seemed to me that the new 45.1 was about was an attempt to overturn or neuter the effect of the Doyle approach, whereby you can get into these fairly sterile disputes about whether you've agreed fixed costs or standard basis cost. But I don't think it works on either level. I think as a matter of construction, your contractual rights must be preserved and the statutory provisions must be read down to that effect. And on the alternative basis, just as you can admit anything or agree anything, whatever your notional rights are, why would this provision be supercharged and tungsten-proofed so that it takes away your freedom of contract? I just don't see it. We're getting some other interesting points, which I'll just deal with briefly. Will fixed costs apply to judicial review? No, because they apply to money claims, not public law claims. Do we know what an issue is in Band 1? No, but the reality of the matter is it could be any issue, but I suspect there will be very few cases where there is only one issue. 3, is it too late at the age of 60 to consider a career change? Well, it's never too late. And the reality of the matter is that we all live many lives these days before the end comes. And the further point that has been raised in the chat is, does it give defendants any rights to get costs in cases which are made but not issued? The answer is no. You have to issue proceedings in order to invoke the court's jurisdiction to make a cost order. So I think if I pass it back to you, Paul, because, we're already 23 minutes from the end.
Yeah, 45.6 then, dealing with looking at defendants' costs. Now, 45.6 provides that where an order for costs is made in favour of the defendant, the allowable costs are the fixed costs set out and the disbursements allowed. So, in essence, the defendant, what that does is affect a parity with costs that are awarded to the claimant. So there's no distinction drawn between claimants and defendants' costs. So defendants need to look at the tables just as do the claimants. The only point that's worth noting is, of course, defendants' costs are set out, the relevant costs will be awarded in certain circumstances by reference to the value of the claim, percentage of the value of the claim. And that is the amount that's specified in the claim form, and in familiar terms, without contributory negligence, and excluding, as Andrew mentioned, any amount not in dispute. There are certain deeming provisions that exist with regards to the value of the claim for the purposes of the defendant's costs, but it's worth bearing in mind that one of the provisions that is that where a claimant cannot say how much they intend to recover, the default position for the purposes of damages on a defendant's costs order is the maximum. It's £25,000 with regards to Section 6 and £100,000 with regards to Section 7. So one could see that certain claimants may fall foul of that in the event they don't specify how much they expect to recover. They could be hit with a percentage of £100,000. That's defendants' costs. And as far as counterclaims are concerned, another interesting provision, part 45.7. Now, counterclaims, where the defendant brings a counterclaim and a court makes an order for costs, then that counterclaim is seen for the purposes of the fixed costs rules as a claim. And so where a court makes an order for a defendant's costs, those costs will be as if the counterclaim was a claim. And that is effectively an overturning, at least for these purposes, in the context of fixed costs of the Medway Oil order, or the rule in Medway Oil, in circumstances in which both parties agree cross orders for costs. Defendant paid the claimant's cost of the claim, claimant paid defendant's cost of the counterclaim, and claimant's costs of the defendant's cost of the counterclaim are usually minuscule because they're on a standard basis because of Medway Oil, they're only the costs over and above the cost of the claim. Well, in this case, there's a parity, and so there's the claim and counterclaim carry their own costs entitlement. So far as the detail of the costs are concerned, I'll pass on to Andrew to highlight the costs of interim and pre-action applications, which are not going to be great news for those parties who to date incur great costs on those sorts of applications.
Yes, and here it's Rule 45.8, and you may recall that before the introduction of fixed costs in PI claims in 2013, the last tranche of them, interlocutory applications were relatively rare, because you'd have a situation where if you lost one, it really stung. You go down for a few £1,000s worth of cost. When the rules were brought in, that effectively it came to £250 by way of recoverable costs plus a court fee or whatever, the courts were choked with applications because the downside was limited. And if you got a unless order or a tactical advantage of that nature, there's a price well worth paying. Well, now what we have are interim application fees and pre-action application fees, effectively pegged at £250, £333 or £750, which is a fraction of what it would take to get even fairly modestly scoped application off the ground. So the idea may be to discourage such applications being made. The effect will be to encourage them from those who take the view that it's worth a punt to try and have an interlocutory battle along the way in the course of a claim. So, Paul, if I pass back to you for exceptional circumstances.
Yeah, one point on that, Andrew, is what I noticed when I looked at the pre-action and interim applications costs is, of course, it's effectively fast track 1, 2, and 3. It's £250. Fast track band 4, it's for £333, and the and intermediate track and NIHL. And the only time you get £750 is for a summary judgment application and an interim payment application, or an interim injunction even. Those costs really are going to be a fraction of the costs that are spent on those applications, particularly summary judgment, if they are run fully. Anyway, Part 45.9, we're all familiar with Ferry and Gill. It may be that the attendees of this talk have had greater success in establishing exceptional circumstances than I have, but it does seem to me that it is a provision that I accept it should be the exception rather than the rule, but it does seem to me to be a provision which it is almost extraordinary in the rarity of its application, and that does need it seems to me that it needs some further judicial consideration or a statutory revision. It's retained for amounts of costs, it's retained for the purposes of intermediate track costs and fast track costs, and so it remains a provision that the courts permit, although plainly don't encourage. CPR 45.10, an important provision, and one that probably will give rise to some discussion. And one of the points in the chat I just read, actually, while we were toing and froing, is whether or not what the response will be to the vulnerability criticisms in the APIL JR. Well, one of the points that's addressed in CPR 45.10 is vulnerability, and the court will consider a claim for an amount of cost greater where a party or a witness is vulnerable, and where the vulnerability has required additional work to be undertaken, and that additional work alone has caused a 20% increase, an amount that is greater than 20% greater than the amount of the fixed recoverable costs. A lot of questions arise from that. Who is vulnerable, or what is vulnerability in that sense? The other point that is likely to arise as a criticism of that provision is that by the time it is considered, all of the cost has been incurred, whereas Practice Duration 1A, the vulnerability provisions that deal with the practice direction require the court to consider vulnerability at the outset and case manage appropriately. And so it's difficult to see how, and one of the questions I've just seen pop up on the chat is a good one, which is how do you what sort of evidence would you need to prove vulnerability, I suppose, and put that before the court? But more importantly, how do you demonstrate the 20% increase that pertains to vulnerability alone within the context of a fixed cost regime where you're going to try to cut your cloth to tailor to ensure that the amount of fixed recoverable costs doesn't enormously underplay the amount that you have spent. In effect, what the court requires you to do for 4510 is spend the money, evidence the expenditure of the money, and then take your chances as to whether or not you're going to get the cost back, rather than proactively case managing it. That seems to me to be a bit of a difficulty, Andrew.
I think, Paul, you're right, because it's a philosophical or logical incoherence in the system that we're meant to be dealing with the cost prospectively. So that's why you have this scheme of fixed costs so you know where you stand. But there's this huge gap where if you're representing the vulnerable, you don't know where you stand. You don't know whether they're vulnerable enough to require you to hit this arbitrary 20% measure. And because people are vulnerable, it means that they may have very different needs. And it may well be that those needs will manifest themselves in different ways. So it's a real element of uncertainty, and it just goes to show that someone has cobbled this together from preceding provisions, the old 45.29J, without really thinking through how this will work in practice. If we move on, because I know time is pressing, 45.13 is unreasonable behaviour. And if unreasonable behaviour is found in a case, you can ask for a 50% uplift on your fixed recoverable costs. So what is unreasonable behaviour? How high is the bar? How exceptional does this have to be set against the usual vinegar and marmite of litigation? Well, it struck me looking at it that one obvious example of unreasonable behaviour might be failure to engage in ADR or mediation when offered. Because again, the thrust of the zeitgeist is that ADR is the way forward. Now, if someone doesn't even bother to respond to an invitation or does so unconvincingly, that might be an example of unreasonable behaviour. But what are your thoughts, Paul?
Well, I see the need to consider ADR as being pretty important in this regard. Although, because obviously the governing law in relation to reasonableness of undertaking of consideration of ADR is the Halsey case and the BGF cases. That remains the standard. Although each case obviously will be treated on its own facts, it strikes me that one strategy that might be utilised by one or other parties in this sort of case is precisely that. It's easy to invite a party to mediation or to a JSM or to negotiate matters between themselves, and in the event there's no response, the courts are pretty clear that they'll view that conduct as potentially unreasonable. It is defined in 4513 as conduct for which there is no reasonable explanation, although I'm not sure that gives us any greater insight into whether or not the standard of reasonableness is a sort of wasted costs standard, or whether it is reasonableness simpliciter. And I would expect that there would be a fairly significant amount of litigation on this, not least because the reduction doesn't appear to be a flexible reduction. I don't see the rule as providing for a reduction of up to 50% or over 50%. I see the rule as providing for a reduction of 50%. So it's an almost you can't sort of win in parts. You either get the 50% reduction or a 50% increase, or you don't. And in circumstances in which some of these costs can be very significant indeed. I would expect that to be something that people would run, subject, of course, to the point that might be raised in relation to it, which is whether or not what the costs of the costs of recovery, the recoverable costs of the application would be, and would that be seen as an application which wouldn't postdate the costs order? Would it be an interim application? One presumes that the court would be keen to see that as an interim application, so the costs of running it would be either or losing it would be pretty small. So I see that would be something that gives rise to a lot of satellite litigation.
We've got quite a bit to get through still. So I thought we might pass over the source of pain that is counsel's fees and how that's dealt with under the fast track and intermediate track. And in the last few minutes of the talk, look at some of these worked examples. What I thought we could do is think about how some typical cases might play out, which would currently be subject to standard basis hourly rate costs, and how they might be dealt with under the new system. So the first example I thought was, well, let's have your 2-day boundary dispute where Mr. and Mrs. Smith are banging heads with Mr. and Mrs. Jones along the fence line. That's the sort of case which would involve allegations of trespass or nuisance, claims for injunctions, modest damages, and declaratory relief. Now, that case going forward, even if it was claiming a modest amount of damages, 10,000, 20,000, whatever is thought to be appropriate, and even that can be dealt with in 2 days, and even though there may be no more than 2 experts aside, might not be appropriate for the intermediate track due to the operation of Rule 26.98, which says that when non-monetary relief is sought, only if it's in the interest of justice will the case be allocated to the intermediate track. Of course, if it is allocated to the intermediate track, which band would it go to? If we assume that it goes to band 4 and is ultimately concluded as these things are at a 2-day trial with a reserved judgment, then the sort of figures we're looking at are fixed costs of £51,000, advocacy fees maybe 2,300 for post-issue advice, 2,900 for post-defence advice, a brief fee of 5,800, refresher of 2,900, and 580 for handed-down judgment. But that's the sort of case which, at band 4 on the intermediate track, represents the top end on the recoverable costs. But I mean, Paul, do you have any observations on how that compares with where we are now?
Well, I think that it's fair to recognise that £51,000 worth of fixed costs would be significantly less than this matter were it to be allocated to the multi-track. And so the difference between it being allocated to the intermediate track, band 4, and notched up in terms of complexity to be allocated to the multi-track would be something that the parties would probably have an enormous fight about, because recognising that advocacy fees for a 2-day dispute like that would be limited to a £5,800 brief, 2,900 refresher with about £6,000 worth of costs up to that point. I think if that represents the high point, then people will start rapidly seeing that there are many lower points in the fixed cost regime, and there'll probably be a lot of argument trying to get cases out of the normal track into the multi-track. The next one that I think, unless you've got something else to say on that, Andrew, the next one that I was going to mention was something that probably segues quite nicely into this one, from that one into this one. Professional negligence claim, for example, of £110,000 value, so not insignificant, but one that slightly overpleaded settles for under £100,000. And so it is a case for a monetary claim for less than £100,000, and it settles pre-issue, but after obviously a significant amount of work has been done. CPR 4549 provides that fixed costs on the intermediate track will be allowed for the costs which are to be allowed in any claim which would normally be or is allocated to the intermediate track. So where the parties agree a figure for costs, unless they expressly agree to contract out of the provisions of CPR 4549, perhaps, if there's a standard basis cost order and the parties agree that costs should be paid, then it will be open to a defendant to argue that this would have been allocated as a normal track to band 4 of the intermediate track. Now, if that was the case, then the costs would be table 14, which is the intermediate track table. Table 12 is the fast track table. Table 14, stage 1, and the amount that would be permissible is £16,900 because it's £9,300 plus 8% of the damages, with no provision for counsel's fees. Now, it's inconceivable, isn't it, that on a professional negligence claim that settles for just under £100,000, there wouldn't be some additional counsel's cost in dealing with advisory work, and that the amount of legwork the solicitors would have had to front load in order to get to a settlement of that value wouldn't be significantly more. So early settlement cases of high value look to me to be a particularly vulnerable category.
I think that's right, because it all looks so simple in retrospect, but you might have to do a lot of work to get to that £95,000 settlement. And if we consider, for example, a personal injury case, which is 75 to 100,000, so a significant personal injury case, that is likely to be allocated to the intermediate track. But will it go to band 3, band 4, or band 2? I couldn't tell you at the moment. If it's settled at stage 6 in the table, so 21 days before trial, if it was in band 1, you get £5,900 plus 15% of the damages. If it was in band 4, conversely, you get £24,000 plus 18% of the damages. But the oddity in this table is that if it was a fast track case of that value, and some cases, very high value cases, do go to the fast track. Anything under £100,000 road traffic accident case in London goes on the fast track. Then if it was in band 4, you'd get £7,900 and 40% of the damages. So in effect, you'd get more than you would for an intermediate track allocation. And that just sounds bonkers to me.
Yeah, absolutely. Well, there are going to be these anomalies. I suspect where cases are where cases are allocated to tracks which are other than the normal track, and there are percentages of damages involved. I suspect the rule drafters will say we didn't anticipate that cases of that value would be dealt with on that track, and therefore the percentage of damages is grossly over-represented of the appropriate costs. Who knows? But I think what we probably have shown, without seeking necessarily to start to concern people, is that there are lots of different issues, interlocking issues to consider with regards to these new rules.
Right. I think we're down to the last 2 minutes. So, Paul, are there any final thoughts from you, or any advice informally that you'd offer at this stage?
Well, it's going to be a case of getting data from a set of cases relatively quickly, it seems to me. The solicitors who can analyse their own cases and costs recovery by reference to a solid data set will probably be best informed to run these cases in the most economic way possible. That's not going to stop, seems to me, the specific arguments with regards to costs, for which, of course, we're always around to discuss and to help with. And no doubt, this won't be the last word on fixed costs. What about you?
Well, I think effectively what I see going forward are 2 years of pain while the new system beds in. But I think the immediate priority for solicitors who are having to grapple with this in the next couple of weeks is to sort out your retainers, sort out your advice to the client on shortfalls, because these aren't fixed costs, these are fixed recoverable costs. And it doesn't mean you can't charge the client more. But unless you want to end up in a solicitor-owned client dispute 2 years from now, you have to make sure your retainers and your advice to the client is set out clearly, fairly, and in writing, and is accurate. So I suppose that's where I'd leave it. You've been wonderful. If you want to see this again, there will be a recording. The slides will go out to everyone. But thank you so much for joining us here tonight. Good evening.
Thank you very much. Good evening.